Ms. Lundy, everybody may be seated, and I apologize for interrupting you in the middle of closing.
I'm terribly.
The behavior from Mr. Bloom, I am not going to have in terms of his gestures, his noise, and everything, particularly behind Ms. Lundy's back. Not going to have it. Mr. Burnton, I'm going to give you a chance to talk to your client about it and tell him that he is to sit there quietly or not at all before I continue. Take him back. Court is standing in recess. People having rested. Any witnesses for the defense?
No, Your Honor. Thank you.
All right, very good. Parties prepared for closing argument? You may proceed.
May I move the question?
Depends on where you want to put it, but yes, you may go.
Buckle up, guys. Today we're going into a courtroom already on the edge. The judge barely begins before freezing the entire room, calling out Bloom's disruptive gestures and noises right in the middle of closing arguments. The tension is instant, the tone is set, and everyone realizes this trial won't be smooth. Court goes into recess as the judge demands order.
That's all right. That's fine.
Good afternoon. When we started this morning, I let everyone know what I expected the evidence would show. Started talking about that Rocky Isley was a nurse working in the jail, and on that date, the defendant was incarcerated in the jail. Talked about how we were going to hear from different witnesses about the defendant reporting to experience a medical emergency. We've heard from 3 different witnesses. First, from Officer Naveen, talked about how that was his assignment that day. The defendant had been upset that day. He talked about how he was upset even earlier in the day. He understood that the defendant was upset about something that had happened before Officer Naveen had even gotten there that day. We heard that he cannot ignore anyone's request for a medical emergency. Because Officer Naveen, Officer Tweedale, and Nurse Rocky Isley have a responsibility to make sure that the people in the jail are safe.
All right, guys, as proceedings resume, the prosecutor wastes no time building her case. She outlines what the evidence would show, weaving together the defendant's earlier agitation, a claimed medical emergency, and witness testimony from officers and medical staff. This moment becomes the foundation of the entire narrative, showing how the day's tension had been simmering long before court began.
That's their job. The corrections officers are there to make sure that the folks who are in the jail are okay. They don't make the decisions about who goes there. They don't make the decisions about who leaves. Their responsibility is safety. Officer Naveen is talking about how he checks every 15 minutes, make sure the people that are in his cell block are okay. He talks about how he makes sure Mr. Bloom is okay. Nurse Rocky tells you about how it's his responsibility when someone says they're experiencing a medical emergency. He doesn't care how old they are. He doesn't think something's more or less likely based on their age. He doesn't think something's more or less likely based on who they are. He is there to make sure they are okay. Officer Tweedale is the one who speaks to the defendant and says to him and gets him to calm down enough to be medically evaluated. Why? Because it's his job. That's his job. He's got to find a way to communicate with each person to help them. Nurse Rocky, I'm sure everyone has experienced a nurse who made you feel safe, who made you feel cared for and listened to. And Officer Tweedale, when this is going to go down and he knows that Mr. Bloom has been upset, and he knows that Mr. Bloom has been agitated. He told you how he levels his hand above the food slot door just in case. Why would you do that? Just in case. Safe. But the only person out of these 4 men.
The prosecutor moves deeper, describing the roles of every witness who crossed paths with Bloom that day. Officers checking every 15 minutes, staff required to treat all medical emergencies seriously, and a defendant who had been upset long before any evaluation began. The story sharpens here, revealing a pattern of distress, protocol, and attempts to maintain control in an increasingly unstable situation.
Who didn't care about the safety of another person was the defendant. You're going to get jury instructions in a few minutes that display for you and educate you that the law does not allow sympathy nor prejudice to influence when you are making this decision. You should not be prejudiced against the defendant because he was incarcerated. And nor should you be sympathetic to him because he was incarcerated. The law requires an examination of the facts. And the facts are simple. The facts are the defendant was in the jail in Washtenaw County. The facts are that the defendant said he was having a medical emergency. The facts are that earlier in that day, he'd been very upset he was not allowed to get out of his cell. The facts are that he was a level 1 security. The facts are that he had to be medically evaluated through his food slot. And the facts are that when he was being medically evaluated, he yanked his arm back in that food slot, and that slammed Rocky Isley into his wall, or into his door, rather. Now, I can't tell you what defense argument there might be, but I will tell you that you've seen a video, not my favorite angle. You've seen medical records.
Now the stakes rise. The prosecutor walks the jury through the pivotal moment of the case, the arm yanked through the food slot that slammed the nurse into the door. She reminds them of the video evidence, the medical records, and the written statement taken immediately afterward. This section forces jurors to confront the physical reality of the incident rather than any emotional interpretation.
And you've got a copy of Rocky Isley's own statement that he made on May 31, the day after this happened in the night, about what happened. Everyone has a right to be safe at work. Everyone has a right to be safe at their homes. All of the witnesses that you've heard from today helped to keep the defendant safe at his home. His home he didn't choose. He didn't choose to be in the jail, but that's where he was. Each of those men told you how they made a choice to keep him safe, despite his behavior, despite his influence.
Stop for a moment.
I'm sorry,
I apologize. Mr. Take the jury, please.
I'm so sorry, Your Honor.
No, it's not you. It's not you. Take the jury, please. Ms. Lundy, everybody may be seated. And I apologize for interrupting you in the middle of closing.
I'm terribly
The behavior from Mr. Bloom, I am not going to have in terms of his gestures, his noise, and everything, particularly behind Ms. Lundy's back. Not going to have it. Mr. Burnton, I'm going to give you a chance to talk to your client about it and tell him that he is to sit there quietly or not at all before I continue. Take him back. Court is standing in recess.
All right.
United District Court of Washington State of Michigan is now back to the Judge Jay Simmons.
You may be seated.
Just as the prosecution builds momentum, the courtroom unravels again. Bloom makes new gestures behind the prosecutor's back, forcing the judge to stop everything for a second time. The jury is removed, counsel is stunned, and the judge's patience snaps into a firm warning. This moment shows how delicate closing arguments can be when a defendant becomes an active disruptor in their own trial.
And if we can bring Mr. Bloom close. Calls the case of People versus Jeffrey Bloom.
People.
Good afternoon, Mayor. Sam Bernstein with and on behalf of Mr. Bloom.
And as I've apprised counsel, during the course of the trial, Mr. Bloom, I don't know, and I'm going to assume that, at least for these purposes, that you weren't doing it intentionally. There have been comments which I could hear all the way up here, and I'm sure the jury could hear it during the course of these proceedings, that then when Ms. Lundy got up to give her closing argument, there were additional comments. I didn't do anything about that, but the moment the gyrations with your hands occurred behind her back, I stopped the proceeding. I'm not going to tolerate any of that. I will stop it again if that's what we have to do, but I'm going to admonish you and warn you at this time that the court is not going to allow that type of conduct to occur. With that admonition.
When court resumes, the judge addresses Bloom directly, documenting every inappropriate comment and gesture made throughout the trial. Defense counsel tries to clarify, but the judge stands firm, refusing to allow further interruptions during closing arguments. This part captures the shift from simple warnings to a formal judicial admonishment, making clear that Bloom is approaching a serious procedural line.